Hello and welcome to MRA's 5-Minute HR Feed, the podcast where you get quick, practical information about a hot topic. Looking to keep up with the rapidly changing HR landscape? MRA has got you covered. In the time it takes to make a cup of coffee, you'll gain insights on hot topics and pressing HR issues. I'm your host, Rebecca Jacobs, and we're so glad you're here. Now it's time to dive in. So, of course, before I start, I have to give the disclaimer. I am an employment law attorney. I'm now general counsel for MRA, the Management Association. I was an adjunct professor at The Ohio State University's Business School teaching employment law to students pursuing their master's in human resource management. But nothing in this podcast is legal advice, and you should always confer with your own attorney before making any decisions. So think of this podcast as just a nugget of good practical information to take away. So today we're focusing on the Pregnant Workers Fairness Act, and specifically, what kind of accommodations do we need to extend to our pregnant workforce without having to go through the necessity of asking for medical documentation? Sometimes it's not clear. Sometimes it is not clear whether a pregnant employee needs a particular accommodation for changes in their work duties, changes in their schedule, things like that. Some things are not obvious. Well, when Congress passed the Pregnant Workers Fairness Act, they said, essentially, listen, there are going to be some things which for pregnant workers are just so obvious that we are not going to require them to provide medical information. So what are those accommodations? So the ones that we need to extend absent very unusual circumstances without medical documentation are, first, allowing that pregnant employee to carry and drink water in their work area. You can imagine that there are probably some manufacturing places where it would be very unusual for someone to be bringing drinks in with them. But this is something that we would need to discuss an accommodation of without requesting that medical documentation. And then allowing an employee additional restroom breaks. Third, allowing employees to sit if they need to, if they're normally required to stand. Or on the flip side of that, allowing those employees to stand if normally they are sitting during the day, and of course, as needed. And then fourth, in the federal law, is allowing an employee additional breaks to eat or drink as needed. So the EEOC has indicated, that's the Equal Employment Opportunity Commission, has indicated that these will be found to be reasonable accommodations that do not impose an undue hardship in virtually all cases. Now, I can imagine a situation like a clean room, for example, a room that has been very specifically cleaned, very important filters. You're working with chemicals or with tiny instruments, or where everything has to be absolutely clean. I can see in that situation that there would need to be a discussion about allowing food or drink in that space. And perhaps we would have to discuss an alternative, such as, well, maybe we're going to be more flexible with when you're taking your breaks because we understand that you do need to have that food and that drink, but we may not be able to have that in that location with you. So it will be interesting to see how these play out. For those of you listening to this podcast in Minnesota, there is yet another accommodation which you are going to discuss and offer to your employees, of course, absent undue hardship, without requiring medical documentation. And that is if that person has a lifting restriction of 20 pounds or greater. So if you're not in Minnesota and your employee comes to you and says, I can't lift anything heavier than a certain weight, 10 pounds, 20 pounds, 30 pounds. That is something where you would be entitled to say, okay, well, I do need something from your doctor. So next time you go to your doctor or when it's convenient, let's get that documentation that supports that we have this lifting restriction. In Minnesota, they say, no, it's obvious. We're going to extend that accommodation to them. So we are waiting. We're in a strange waiting period right now with the Pregnant Workers Fairness Act, where the regulations have been proposed. The public comment period ended on October 10th. We are now waiting for the regulations to come out. They should be coming out by December 29th. And this is where we're going to see a lot of the very specific expansions. What does it mean to be pregnancy related or a medical condition related to childbirth? Will menopause and cramps be included? So we need to see how those regulations come out, and we will put out another 5-minute feed when those come out so we can make sure everyone is up to speed on those. So thanks for listening. And if you have any questions, please reach out to MRA's hotline. And thank you very much. See you next time. Thank you for listening to MRA's 5-Minute HR Feed. For this episode, be sure to reference the show notes where you can sign up to connect for more podcast updates. If you have questions, you can connect with MRA's hotline team by emailing infonow@mranet.org or calling 866-474-6854. Check out other MRA episodes on your favorite podcast platform, such as MRA's 30-Minute Thrive. And as always, make sure to follow so you don't miss out. Thanks for tuning in, and we'll have another hot HR topic in 2 weeks.